Hello, everyone. Good morning, good afternoon, good evening, depending on where you're joining from. It's great to have you all here, and we'll be beginning immediately. For those of us who've joined already, at the bottom of your screen to the right, you would see a globe icon labeled interpretation, where you'll be able to change your language from English to French, Spanish, or Portuguese. You may also want to select mute original audio to mute the English presentations. We would like to head on and begin with welcome remarks from the program director of the Network of Universities Legal Aid Institution, Odinakaonye. After that, we'll take some remarks from Mr. Don Dea, the Chief Executive Officer of Pan-African Lawyers Union. The mic is yours, Odi.
Thank you. Hello, everyone. As Ikechukwu said, my name is Odinakaonye, Program Director, Network of University Legal Aid Institutions, a nonprofit promoting clinical legal education, access to justice, legal aid, public interest litigation, and the development of future public interest lawyers in Nigeria. On behalf of Robert F. Kennedy Human Rights and NULAI, Pan-African Lawyers Union, and the Institute for Human Rights and Development in Africa, we are excited to welcome you all, a diverse group comprising of lawyers, journalists, students, public servants, and other members of civil society from about 45 countries in Africa, Asia, Europe, Australia, South America, and North America. This series focuses on civic space and digital rights in response to the growing trend of internet shutdowns and other forms of state-ordered interference with internet access and use. A cohort of countries are moving towards restricting the digital civic space by embracing the Chinese model of extensive censorship and online manipulation. Authoritarian regimes restrict digital civic space by using of digital information technology to surveil, repress, and manipulate domestic and foreign population. These strategies are reshaping the power balance between democracies and autocracies. Securing internet freedom against the restriction of digital civic space is fundamental to protecting democracy. The recent developments in advancement in restriction on digital civic space requires a coordinated strategy to confront ongoing attacks on the digital civic space. There is a need to generate resources and build capacity of CSOs and the public to confront ongoing attacks from all fronts. This series provides us all a great opportunity to interrogate approaches and articulate innovative legal engineering needed to mount countermeasures in securing our freedoms. We are excited about the diversity of perspective you all bring to this discussion, and we really look forward to a robust conversation. I welcome you all to this series. Thank you so much. I hand over to Mike to Daya.
Thank you so much, Odi. We should have welcome remarks from Don Dea, who is not here yet because of some technical hitches, but we'll take that after the first session. Our first session would focus on, our first session would be presented by Oludayo Fabuni, Senior Legal Officer at the Institute for Human Rights and Development in Africa. He will be speaking presenting an overview of the ECOWAS Court, the structure, jurisdiction, and procedure. You can find Dayo's bio in the chats. Dayo, the mic is yours.
Thank you so much, Ikechukwu and other colleagues. It's my pleasure to be here to address this distinguished audience and to give us a short summary of the ECOWAS Community Court of Justice and how the court can work to defend human rights. I have a presentation which is about 21 slides or so, and I've been told I have just a few minutes to speak, so I may not strictly follow the presentation. Okay. Now, the Economic Community of West African States was set up in 1975 as a regional economic bloc for West Africa for the purpose of promoting trade, primarily promoting trade between states. And so at that time, the interest of the ECOWAS was not so much about human rights. The 75 treaty creating the ECOWAS did not make a mention about human rights. But in 1993, that treaty was revised, and the revision made reference to human rights, particularly referencing the African Charter on Human and People's Rights. And so human rights came on the agenda of the ECOWAS Court. Meanwhile, between 75 and 93, the ECOWAS Court itself the protocol creating the ECOWAS Court was adopted in 1991. And as such, can I go on? And as such, when the court was created in 1991, by that protocol, human rights was not part of the agenda. The court itself, even though the protocol was adopted in 91, did not become functional until 2001. And then the rules of procedure were adopted in 2002. But as you can imagine, at its creation, it wasn't a human rights court. So the rules of procedure did not envisage human rights litigations. But subsequently, there were a couple of cases brought by human rights activists to the court on human rights violations of human rights provisions, and the court had to throw them out because the court had no jurisdiction. This led to calls for a supplementary protocol, which was finally adopted in 2005. By virtue of that supplementary protocol, the court now has jurisdiction to hear human rights cases and under certain conditions. Also, the supplementary protocol expanded the jurisdiction of the court by granting access to individuals to bring human rights cases before the court. Before that, only states and ECOWAS institutions could bring actions to the court. Now, the ECOWAS court now has 5 judges. The court used to have 7 judges until a couple of years ago when there were some amendments. And so now the court has 5 judges appointed by the ECOWAS Authority of Heads of States and Governments. The court usually sits in a panel of 3 with a presiding judge and 2 other judges. In addition to the judges, the court has a registry where you can file all your documents relating to the case, and then the registry also keeps all documents and correspondence. The court is located in Abuja, which is the capital of Nigeria. Now, in terms of applicable law of the court, the 1991 protocol and the supplementary protocol empower the court to adjudicate on disputes relating to the ECOWAS treaty and all other ECOWAS protocols, conventions, regulations, or directives. For the human rights mandate, the court can apply all international human rights instruments ratified by the defendant states. That's the state being sued before the court. But the court cannot apply national constitutions or laws. Now, the court is empowered under Article 19 of its protocol to apply the body of law contained in Article 38 of the Statute of the International Court of Justice. And so that gives the power to the courts to apply customary international law, to apply all treaties ratified by that state, to apply the general principles of law recognized by civilized nations, as well as apply the writings of most qualified publicists and jurists. Now, in terms of the human rights jurisdiction of the court, cases can be brought against any member state, but there's this controversial provision which has led to some conflicting decisions. Recording in progress. Of the supplementary protocol, which provides that any action by or against a community institution shall be statute barred after 3 years from the date when the right of action arose. But if you look at this quote, as I have lifted it into this presentation, I have literally translated the French. In the English, what it says is that any action by or against a community institution or member of the community shall be statute barred after 3 years from when the cause of action arose. So that has been interpreted in a number of cases to mean that human rights cases against states will be statute barred if you file them more than 3 years from the cause of action. And for that, you could see the Dorothy Njemanze case against Nigeria. But subsequently, in the case of Federation of African Journalists against the Gambia, when the court had to also look at this question, the court relied on the French version being the first version of the protocol to be adopted, and realized that in the French version, it says community institution, but not member of the community. And in that case, the court held that the statute bar does not apply to human rights cases. But then subsequently, there's been another panel of the court in a 2019 case, Ebere Amadi and others against Nigeria, that has applied the statute bar to a human rights action. So what the court will do in this situation remains unclear. But I'm aware that there are a number of cases before the court now in which the court has to rule on this question. So we'll see whether the court will go back to the stand it took in the Federation of African Journalists case or continue to apply the statute bar to human rights cases. Now to talk about access to the court. Access to the court is quite wide, and member states, the ECOWAS Council of Ministers, the Executive Secretary can bring actions before the court. But for our purpose here, the most important one, the relevant one, is that individuals can bring applications to the court for relief for violation of their human rights. In practice, the court has interpreted this to mean that NGOs can also bring applications on behalf of individuals and in the public interest. So even though the protocol expressly talks about individuals, NGOs have been held to be included in that list for human rights cases. Now, for the purpose of admissibility, there are only two requirements. One is that the application is not anonymous and it indicates the author. And the second is that it should not be instituted while the case is pending somewhere. You must note that you do not need to exhaust local remedies. Now, to file cases, you need to send the brief to the registry of the court. And now, since the COVID-19 lockdown started, all documents are now filed by email, and counsel or agents must include their email addresses and WhatsApp numbers for service to the court. The briefs to be submitted should not exceed 15 pages, which is also sometimes problematic because lawyers want to submit extensively. After cases are filed, the defendant state can also respond, and then the applicant has a right to respond back. And subsequently, you can have an oral hearing where witnesses can be produced and where the lawyers or agents can argue the cases orally. Parties can only be heard through their agents or lawyers or legal advisors. And such lawyers have to be lawyers admitted to practice in an ECOWAS member state. In terms of special procedures before the court has no express provision for amicus curiae, which is friends of the court, which could provide information on specific subject matters before the court. But in some cases, the court has allowed amicus. In some cases, the court has not allowed them. And then another procedure which one must talk about is the provisional measures procedure, which allows the parties to apply to the court to maintain the status quo, to prevent irreparable harm to the subject matter of the case. And then third parties interested in the subject matter of the case can join the suit by the procedure of intervention. And then by the procedure of joinder, the court can join cases together. If you will please give me 1 minute to please summarize about the decisions of the court. After all the written procedure and hearing procedure, the court reaches a decision which is usually read in public and which is binding on the member state and which the member state has to enforce. Each member state has to indicate a competent authority for doing that, and only about 5 countries the last time I've checked have complied with this requirement. That's Nigeria, Mali, Guinea, Burkina Faso, and Togo. It's difficult to fit talk about the ECOWAS Court into 10 minutes, so I'm sorry this could not be explained as much as I would have liked to do, but thank you so much for your time. Perhaps we might have more time in the questions. Thank you so much.
Sorry, I was muted. Thank you so much, Dayo. Thank you so much for that very insightful presentation in the very short time we had. And thank you for the presentation, which we will be sharing with all participants. And would ask you that if you have questions for Dayo, please, you can share those questions through the Q&A function in any language that you choose, or in any language that you speak. And then, we would get to the questions at the end of the session. And even after the webinar, we would have a post-webinar interactive session through a designated platform that we'll talk about later, where all questions would also be addressed. Thank you so much, Dayo. We'll now move to getting another welcome remark from one of the partner organizations that has put this webinar together, and that would be Don Dea, the Chief Executive Officer for the Pan-African Lawyers Union. Don, the mic is yours. You're muted.
Sorry.
Okay, it's fine now. We can hear you. Thank you.
I thought so. Thank you very much. And I'm sorry that I'm joining a bit late. It was just Murphy's Law that at the exact clock of 5, electricity went off in Arusha and I had to scramble to get the generator on. I apologize for that. Since we have already started, let me skip some of the other remarks that I've said. And I just said that amongst the principles that PALU, the Pan-African Lawyers Union, regards very highly, right from our constitution to our vision and mission, are 3. Progressive realization of all human and people's rights, principled multilateralism, and solidarity. And these 3 principles, these 3 aspirations, we regard them highly for both within the continent and globally. And to say, as you may know, the regional economic communities, the RECs in Africa, are conceptualized and are designed as building blocks to continental unity. So ECOWAS in West Africa, East African Community, SADC, COMESA, CEMAC, the Central African Monetary and Economic Community, they are regarded as building blocks. They are therefore important in and of themselves as international institutions, but also for the continental project. And to just highlight that at the continental level, our states have adopted a package of legal and policy instruments, which we call the shared values instruments. These are instruments that lay out the continental standards for democracy, for good governance, for the just rule of law, and for the promotion and protection of human and people's rights. So these are the various treaties and charters, starting with the African Charter on Human and People's Rights, its protocols, the protocols on the rights of women, protocol on the rights of elder persons, protocol establishing the court, and so on. Now, each and every of the recs are required to align themselves to these standards, these shared values of the African Union. And in fact, they're encouraged to surpass them, to go even further. So it is in this light that we are now placing focus on ECOWAS, the Economic Community of West African States, in its totality, not just the court, because here in particular, of course, we are focusing on litigation at the court. But remember that the standards on human rights, on democracy and governance place obligations on other organs and institutions of ECOWAS, its parliament, its summit of heads of state, the secretariat, and so on. Now, this focus on ECOWAS, we have previously done it for the EAC, the East African Community. We're very glad that now we are putting our singular focus on ECOWAS. And of course, in later periods, we'll put it on the other recs. And to speak about solidarity, the spirit of solidarity requires us all to be in solidarity with our colleagues in ECOWAS as they activate ECOWAS and as they ensure that it works for their people and that it protects and promotes human and people's rights. It is on this basis that we as PALU are very pleased and honored to be able to co-convene this with our sister organizations, with our partners, as we strengthen action all over Africa and ensure that we have linkages and solidarity with actors, not only from all over Africa, but from all across the globe. Thank you very much. And let's go back now to the substantive presentations.
Thank you so much, Don. Thank you for that. We would move briefly to the panel session. We have an exciting panel for you all. We can see the questions coming in. Please continue to send your questions and we'll get to them shortly. All speakers would remain on the call till the end of the event. To take us further in today's webinar, we have the honor of inviting 3 distinguished experts to discuss global trends in civic space attacks and the enabling role of strategic litigation. First, we would hear from the United Nations Special Rapporteur on the right to peaceful assembly and association, Mr. Clement Voule. Special Rapporteur Voule is known to most of us through his exceptional and long-standing work on civic space. You would find his full bio in the charts. Mr. Special Rapporteur, the floor is yours.
Thank you, Ike. Thank you very much for the introduction, and also thanks to other panelists that introduced also Dayo and others, the court. Good morning, all of you, and thank also for the organizer, Pan-African Lawyers Union, the Robert Kennedy Human Rights Center, the Institute for Human Rights and Democracy in Africa, and the network of university legal aid institutions for inviting me to this exciting series of webinars. Let me say that over the past 10 years, the world have faced a series of severe challenges: growing poverty and inequality, violent extremism, conflicts and war, a rapid transformation, natural disaster, and climate change, and now a global pandemic. The need for assembly and association rights as an avenue for people to work together through peaceful means towards solving this problem is evident. After all, through history and across culture, the right to freedom of peaceful assembly and of association have enabled individuals to address many world's most difficult challenges. However, instead of listening and responding to people's needs and expanding the ability of civil society to contribute to addressing this challenge, many governments around the world chose to use this crisis to close the space for civil society and increase their own power. Over these years, my mandate has documented this phenomenon. In a report that I presented to Human Rights Council, I identified global trends of the closing of civic space. They are all 8. Allow me to just name them quickly without going or without explaining them one by one. The first trends that I identify in this report is the use of legislation to suppress the legitimate exercise of freedom of peaceful assembly and of association. We can talk about that in Q&A. The second one is the criminalization of an indiscriminate and excessive use of force to counter or repress peaceful protests. The third is the repression of social movements. The fourth, the stigmatization of and attacks against civil society actors. The fifth, restriction targeting particular groups such as women and LGBTI rights defenders, environmental human rights defenders, indigenous people, and union leaders. And the sixth, the increased limitation on these rights, the right to peaceful assembly and association during electoral periods, as the case in West Africa. And the seventh, the rising of populism and extremism. And the last one, the restriction to civic engagement in the digital space. Unfortunately, since I issued this report in 2018, these trends have not reversed. They continue, and in many countries, it intensifies as a result of the undemocratic response adopted to confront the COVID-19 pandemic. While some governments have tried to respond to the pandemic with a human rights perspective, the crisis has been used by many governments as a pretext to cement, control, and crack down on civil society rather than ensuring public health. I'm particularly concerned at how states have increased restriction to access and use of digital technology to silence, sever, and harass civil society actors and to manipulate public opinion before and during the pandemic. The use of internet shutdown is one example, and it's very concerning. Over the last year, the number of governments imposing internet shutdown during mass demonstration and election has continued to grow. And there are several examples in West Africa, which I'm sure we will be talking about. Shutdowns are increasing in length, scale, and sophistication, with shutdown lasting weeks, months, and even a year, and targeting specific application and service most used by peaceful protesters. Some states and malicious third-party actors have also increased the use of digital surveillance and online harassment against civil society actors, human rights defenders, opposition political leaders, and those who plan to stage peaceful public assembly. All of this has significantly reduced the digital opportunity for individuals to join together to defend and promote shared interests. In this difficult context, judicial systems at the national and regional level have a critical role to play at ensuring the full enjoyment of these fundamental freedoms. In my latest report to the Human Rights Council, which I presented in June this year, I stressed that access to justice, the right to freedom of peaceful assembly and association, and the strengthening of civic space are intrinsically linked. Access to justice is crucial to uphold the rule of law and to create, strengthen, and expand an enabling environment for civil society. When access to justice is not guaranteed, people cannot fully exercise their right to freedom of peaceful assembly and of association. That is why my mandate has sought to engage with national and regional courts and submitted 13 amicus curiae briefs over the last 18 years in cases aimed at protecting the right to freedom of peaceful assembly and of association. The goal is to strengthen the capacity of courts in ensuring the right to freedom of peaceful assembly, of association, and ensuring domestic norm and practice complying with international human rights obligation. Amicus curiae intervention can play a key role in supporting national and regional courts advance protection of the right to freedom of peaceful assembly and of association, and serve as an important advocacy tool for lawyers and civil society. This work by the mandate has led to positive results. For instance, in one such case, we filed an amicus brief before the High Court of South Africa, arguing that the country's regulation of gathering acts imposing illegitimate restriction on the right to freedom of peaceful assembly. The South African courts struck down the challenges provision and made extensive reference to the International Court's decision, and authorities cited in the amicus brief I presented. But securing accountability and judicial protection for the right of peaceful assembly and of association remain extremely difficult. Cases brought are often slow moving and subject to delay. When courts do issue decisions, they do not fully incorporate international human rights law consideration, including those related to freedom of assembly and of association. In many instances, courts failed to provide effective remedy to redress victims or prevent repetition. The biggest barrier, however, is the lack of independence and the impartiality of the judicial system. This has made it impossible for violation of the right to freedom of peaceful assembly and association to be known, ratified, and remedied in national courts. This is when regional human rights mechanism and regional courts came into play. Let me conclude by reaffirming that as difficult as these challenges are, there are many reasons to remain hopeful. For example, and I'm sure you will talk about that, cases brought by civil society against shutdown in India and Indonesia resulted in court ruling recognizing that the shutdown were illegal and constituted a human rights violation. The ECOWAS Court issued a landmark decision ruling that shutting down internet access is a violation of the right to freedom of expression. And I'm sure we will hear this from Access Now and Amnesty that who are also joining me in this panel. Courts can and should play an essential role in reversing closing civic space trends. It can, in particular, ensuring that the right to freedom of peaceful assembly and association are protected both offline and online. As my time is now already end, I will stop there. But thank you for listening to me. But I will stay with you, and I'm happy to take any question and any clarification that you may want. Thank you very much.
Thank you so much, Clement. Thank you for that insightful presentation and for sharing the great work that your mandate has carried along this years. We are really, really grateful to you. Just one question before we move along. You mentioned the use of legislation to suppress legitimate exercise of freedom of assembly and association. From your interaction with state parties and your engagement with activists on the ground, can you share a bit about what forms these legislations take and how you're seeing activists on the ground respond to these laws?
Yeah, thank you for this question. And as I mentioned, the use of legislation is one of the, I will say, one of the biggest trends that since I took the mandate, and I'm sure my predecessor also will witness during our work. They can take the form of amendment to the existing legislation, which is already very restrictive, or the adoption of new legislation. And this can also, some of this legislation may restrict the rights for civil society to access to funding, or it may also put restriction or put some burdensome requirements for civil society to create an association. In some country, you have to fulfill so many administrative requirements in order to be able to create an association. In some Francophone country, for example, creating an association or registering an association is not enough. You need also to have another kind of paper, which is called recipe, which then complicates your work, and you cannot access to some funding, in particular some international funding or some donor request of some association to have this registration before they can access to funding. And this legislation also sometimes may look like, if I can give an example of some country which we have also to prevent this legislation to come into force. The limitation in terms of you have to comply, or you have members need to be certain age before they can form an association. So there are many things that this legislation can have, including even, I'm not talking about that, the issue of access to the internet that sometimes is criminalized. You have the cybercrime law, you have also anti-terrorism law, so many legislation that are spread. Sometimes it's not just about the legislation on association, but you have also different restrictions within other legislation that, for example, can criminalize access to internet, access to receive funding, anti-terrorism legislation that have provision that criminalize the work of civil society.
Yeah, thank you so much, Clement. There are a lot of questions that have come in, but we'll take them at the end of the session. Thank you.
Great.
And that conversation around legislations would be a great segue to our next speaker, who is Natalia Krapiva, who is the Legal Tech Counsel at Access Now. Natalia, the floor is yours.
Thank you so much, Ikechukwu. I'm so honored to be a part of this event and join other panelists, distinguished panelists. My name is Natalia Krapiva. I'm joining from Access Now. And I would like to start by talking a little bit about our organization and the global trends in digital rights that we are observing, and then transition to our experience with ECOWAS Court and share some observations on the role of courts in general in protecting digital rights. Access Now is an international human rights organization. We're dedicated to defending and extending digital rights of users at risk around the world. And we do that by combining direct technical assistance through our digital security helpline, comprehensive policy engagements, global advocacy, including through our Keep It On campaign, legal interventions, grant making, and convenings such as our yearly conference, RightsCon. Apologies, I have all these notifications. I'm going to shut them off. And we do that through, apologies. So Access Now was founded after the 2019 contested presidential elections in Iran in response to the actions that the government took to suppress their people's fundamental human rights, such as the rights to freedom of expression and peaceful assembly and privacy, by blocking internet access, censoring content, and undermining the security of their users. And since that time, we have witnessed many more violations of digital rights around the world. So for example, our Keep It On coalition, which consists of more than 240 organizations from 105 countries around the world that monitors and fights internet shutdowns, we have documented more than 760 internet shutdowns in 63 countries since 2016. And our digital security helpline, which is a 24/7 computer security incident response team that provides assistance to civil society at risk, has received over 10,000 requests for assistance since 2013. You can read about this request in our recently published report on the first 10,000 cases. But in that report, we identified the biggest threats to civil society online that we have observed are account compromise, malware, spyware, censorship, denial of service, harassment, and communication surveillance. And these are not just states that are behind these attacks. Companies are often complicit too. Just a couple of months ago, you probably remember the world was rocked by the Pegasus project revelations, which added to the long list of documented surveillance abuses perpetrated by states with the help of companies such as NSO Group against hundreds of civil society actors all around the world, including the West African state of Togo. And a few weeks ago, we also witnessed how tech giants Apple and Google succumbed to the Russian government pressure to censor their app stores and platforms, to remove civil society and opposition apps, videos, and documents. So what we're seeing now is the world's most powerful actors, states and major tech companies, are using technologies to curtail our freedoms and rights, including the rights of freedom of expression and freedom to a peaceful assembly, and shrink the civic space online and offline. But one important way that civil society can fight back is through courts and other legal mechanisms. So we at Access Now understand this, and we have been supporting strategic litigation cases and filed amicus briefs and expert opinions ourselves and jointly with the partners in multiple proceedings on various digital rights issues, including internet shutdowns, surveillance, net neutrality, data protection, and so on, and domestic jurisdictions such as United States, Cameroon, Indonesia, and Brazil, as well as regional courts such as the European Court of Human Rights and the ECOWAS Court. And at the ECOWAS Court, we have intervened in two shutdown cases together with our partners, which include EFF, IFF, CPJ, CEPESA, Paradigm Initiative, and so on. So the case that one of the cases that we intervened in that was already mentioned today is Amnesty International versus Togo, which dealt with the 2017 internet shutdowns implemented by the Togolese government in response to a pro-democracy demonstration. And the recent one, which is SERAP and others versus Nigeria, where the Nigerian government blocked Twitter, allegedly in response to Twitter deleting or not deleting certain content. And in both cases, our briefs were aimed at assisting the court with understanding what internet shutdowns are and how harmful they are, and the growing trend of this phenomenon globally and in West African states in particular, and argued that shutdowns are inconsistent with regional and international frameworks and violate international human rights, including rights to freedom of expression and association, as well as rights to work, health, education, scientific progress, and cultural life. In the Nigeria case, we also paid special attention to shutdowns of major social media platforms such as Twitter. We think that it's very important to engage with ECOWAS Court, as it's not only one of the key regional mechanisms for defending digital rights, but it's also setting the norms on digital rights globally. For example, Amnesty International versus Togo decision was the first regional court decision on internet shutdowns, even ahead of the European Court of Human Rights, which is currently considering for a shutdown case. The Togo decision does an important job of cementing the prohibition against government interference with people's access to the internet in West Africa and around the world. However, while we will continue engaging courts, I also want to point out that globally and regionally, we see judges still being somewhat cautious or reluctant to engage with cases related to digital rights, or they tend to be too conservative in their decisions. And I think this is a mistake. I think that courts, and we think at Access Now, the courts that, including regional courts such as ECOWAS, should not hold back from fully engaging with today's pressing issues and assaults on human rights in the digital age. The international standards relevant to fundamental rights are well established. We do need the courts, however, to clarify and further apply these standards to today's realities. And this is not about something about judicial activism, which some judges may be afraid of, but this is about staying relevant in the age of ever-changing and evolving digital technologies. So the dictators of the world do not wait to repress our freedoms, and so neither should the courts wait to protect them. Thank you very much.
Thank you so much, Natalia. Thanks for centering the conversation on internet shutdowns, as that is the trend that we are tracking globally, but also specifically in the sub-region, in the West African sub-region. So just one question. You talked a bit about why internet shutdowns and why digital rights restrictions contravene human rights law, and why courts across the world should take a more strong stance on the right to access the internet. And you mentioned the Togo case, which we'll be talking a lot about tomorrow. But can you let us know what more you would have expected the courts to do? You know, the court stated that the internet is supportive of other rights and so should be protected. So what's the next step you expected the court to go to strongly ground the right to access to the internet?
Sure, thank you. I do believe, and we have written about this at Access Now, that we think that the court's decision is consistent with international human rights standards when it comes to shutdowns, and they did apply one of the three parts of the three-part test, which is legality, and that's very important. And in this case, it looked like the Togo government didn't have a law in place to justify their actions. But we would like to see courts more engaging with the three-part test, and especially the proportionality, necessary proportionality component of it, and clarifying that in fact, and if you look at it, that the most shutdowns, if not all of them, are by nature just extremely disproportionate to what the states are trying to achieve. That's one thing. And another thing is something that I mentioned briefly, is that beyond the rights to freedom of expression and assembly, we also would like, of course, to more engage with other rights, which is rights to work and health, which especially during the time of the pandemic is important, because all of us are relying on the internet to conduct every aspect of our life, but also talk to our doctors and mental health professionals. And so this is very important for courts to also acknowledge that shutting down the internet also deprives people of rights to health and work and education and so on.
Fantastic. Thank you so much, Natalia. And it was also great that you mentioned that the ECOWAS Court blazed a trail in terms of, you know, establishing jurisprudence around internet shutdowns, and that is something that has supported advocacy around these issues across the world. Thank you so much. We would get to the questions after our last panelist. Our next panelist, ladies and gentlemen, everyone, is Osai Ojigho. She is the country director for Amnesty International Nigeria. Osai, welcome. The floor is yours.
Thank you so much. And it's my pleasure to be joining you all at the session today. And thanks also to my co-panelists for setting the tone. I think they've made my contribution and intervention so much easier. So, to those, just to set the scene in terms of what we do as Amnesty International, we're a human rights organization and a global movement of over 10 million people, which mobilizes the humanity in everyone and campaigns for change so that we can all enjoy our human rights. When we talk of civic space, and what exactly do we mean? I know a lot of conversations have gone on in terms of civil society. But it's important to stress that the civic space is an environment that enables civil society primarily to play a key role in the political, economic, and social life of our societies. In particular, the civic space allows individuals and groups to contribute to policy making that affects not only their lives, but the lives of people that they're advocating for, including by providing the forum to access information, engage in dialogue, express dissent or disagreement, and join together to express their views. Oftentimes when we think of civic space, we think of the most visible space that exists, which is occupied by NGOs because of their advocacy, as well as the mass campaigns NGOs host individually and collectively within networks and coalitions in order to ensure that their messages are carried forward. The Office of the High Commissioner for Human Rights has emphasized that an open and pluralistic civic space guarantees freedom of expression and opinion, as well as freedom of assembly and association, and is a prerequisite for making development and peace sustainable. Therefore, in the work that we do as Amnesty International, we frame the issues around what does this mean in terms of entrenching human rights so that everyone can enjoy their human rights and that human rights are protected. So our engagements and interventions around the civic space has primarily focused on freedom of expression, which has also been shared by the previous speakers, freedom of association as to who can organize and who can bring those issues forward, freedom of association, freedom of assembly, and other issues which have now become even more relevant with regards to the digital space is rights to privacy and freedom from discrimination in terms of access, capabilities, which could also involve things around costs, around availability, and distinctions between rural and urban societies, but more importantly, around what provisions are made to ensure universal access to these new tools. Looking at drivers, trends, and threats, there are several that we can point out that target the civic space. There's natural disasters, terrorism, the policing of protests, media capture, which essentially is the silencing of voices, very progressive voices in the media in order to report or not report on certain incidents. We're seeing a rise in what has been termed illiberal democracies. So on the surface, they look like democratic governments, but rather they are quite intolerant of other voices or alternative opinions. Restrictive laws coming up to limit people's access to information, to government, or in terms of the tools that are made available for them. Economic recession, oftentimes when they push back in terms of trying to deal with the social goods, it's also an opportunity that can threaten civic space and people's opinions with regards to what is best for the state at that point in time. Other threats and drivers are political and economic interests, the growth of CSOs, because the more CSOs, the more civil society organizations that exist, it means that there's a much wider net that the institutions and government agencies have to keep an eye over. Then capacity building. As long as civil society actors are not growing in terms of managing developments that are happening around them, there would always be a step behind what needs to happen next. Bureaucracy, the fact that we are also in a very unequal world, still dealing with income inequality and gender inequalities. Other threats to the civic space are security and safety for human rights defenders and activists, and increased attention to surveillance and using technological tools in order to achieve this. Artificial intelligence being used to map out and actually to target and profile racialized communities or minorities or people from poor marginalized groups. Internet shutdowns, the provisions and affordability of technology, the role of youth in society and whether their innovations and opinions are taken into account, as well as fake news. So looking more specifically at digital threats, which are quite relevant if we have to look at the protection for digital rights, as well as the challenges that are more prominent when it comes to the civic space. I would like to highlight 4 issues. The first is internet shutdowns. This has also been mentioned by previous speakers, but just so that we are clear, An internet shutdown can be defined as an intentional disruption of internet or electronic communications, rendering them inaccessible or effectively unusable for a specific population or within a location, often to exert control over the flow of information. This was provided by Access Now in one of their publications. What we have discovered is that these internet shutdowns are becoming quite fashionable and are deployed during elections on the continent. And to quell protests, as we saw in Cameroon, the English-speaking part of Cameroon, in Togo, and in Chad. And as been highlighted earlier, the ECOWAS Court in Amnesty International Togo and 7 others versus the Republic of Togo was clear that the internet shutdown was a violation of human rights, and that the government's reasons for shutting it down does not justify and does not meet the specific requirements as required for limiting the right to freedom of expression. The second digital threat is restrictive use of online tools and social media. We have seen, like in countries like Tanzania, which introduced a blogger tax in April 2018, as one means through which people's ability to use social media to share information can be a source of target and worry for the authorities. And in Nigeria, where there had been attempts to pass a social media bill on the basis that social media is being used for propagating false news, internet falsehoods, but which was successfully shut down after a wide campaign. But unfortunately, in June 2021, about 4 months ago, the social media site Twitter was banned in Nigeria. It is now the subject of a court case also before the ECOWAS Court, and Amnesty International submitted an amicus curiae on the Twitter ban in the consolidated case of Serap and others versus the Federal Republic of Nigeria. Amnesty International's argument is that Twitter is a veritable means for the exercise of the right to freedom of expression, particularly for the right to seek, receive, and impact information. We all are looking forward to the judgment of the court, which they have announced will be delivered in January 2022. The third area is demonization of human rights defenders and activists, with a particular specific attention on gender-based violence targeting feminist women groups. We have seen a rise in so-called troll farms and online trolls, predominantly on Twitter, targeting activists, trying to create doubts as to what they are saying, or actually pushing out threats and threats of violence against people whose views they disagree with. We recently, as Amnesty International, also released a report on how toxic Twitter can be, particularly for women, looking at experiences of women in Africa, in India, and elsewhere, to show that the social media platform can do a lot more in making online spaces safe for women and other women human rights defenders when they use or they share particularly views which might be considered progressive or not, or liberal on the sites. And the fact that female activists tend to get really strong attacks to their person, including threats of being killed, sexual violence being committed against them, which largely goes untreated on these platforms, even when they complain. And the final is surveillance of human rights defenders. Technology, particularly using malware, is targeting human rights defenders, as can be seen in the Pegasus scandal. So what can we do in terms of what are the opportunities? One key one is one thing that we're doing now, which is education, sharing information, sharing skills in terms of what has gone before, why we all need to work together in order to find ways to push back on these threats that is affecting the civic space and the very essence of our basic human rights. But if we were to look at it critically, we can frame this under 3 issues. One is monitoring and reporting using the human rights mechanisms. So whether it's the UN treaty bodies or the various human rights bodies in Africa, in the Inter-American system, or in Asia or in Europe, one thing is clear: whenever human rights issues are brought to the fore, states have an opportunity to be peer-reviewed by other states in these spaces. And it also offers an opportunity for us to begin to use regional and international spaces for potential strategic litigation, as we have seen has been successful elsewhere. The other two opportunities are building tactics and prototypes that we can use in order to showcase what has happened elsewhere and which can then be deployed in emerging situations. And finally, building partnerships with key CSOs, cross-regionally and international mobilization in order to show that when the rights of one is affected, it affects all of our rights. Thank you very much.
Thank you so much, Osai. Thanks for that and for the great work that you all are doing at Amnesty Nigeria and Amnesty International globally. I'd now like to invite all our panelists to join this question and answer session. We've received a lot of questions. Before we go into them, I'd just like to clarify for the audience that this is a three-part series. The next session, next week, Tuesday, the 12th of October, would focus on crafting litigation strategies to respond to these digital rights and online civic space challenges. And the last would focus on implementation of decisions of courts and the use of those decisions for advocacy. We've received a lot of questions around implementation. We may not take them today just because there's a specific session focused on that, but we'll begin to chat a bit about them if time permits. So I'd like us to start with a question here from, I think is Bonaventure. Just 1 minute. No, the question is from Ayezu Tamara Pere. And the question really focuses on national security and the obligation of governments to uphold the right to freedom of expression and the extension, to online expression and this internet platforms we're talking about. And Ayezu says the issue of digital rights litigation has often been pinned around freedom of opinion, journalists and citizens' rights. In the face of terrorism and the use of unregulated mediums like social media, in breach of national and individual security comes to mind. How do we solve the menace as we cannot continue to interpret these infringements as just digital rights infringements because they have an impact on national security? Is it not yet time to for regulatory associations such as the ITU, regional telecommunications regulatory associations such as the ATU to act on their responsibility by recommendations and synergy with this media? So just the conversation around, the national security justification that we usually see. What is the position of the law on those? I know we talked about the three-part test already, but maybe just to talk a bit more about that. And is there a way for the right to freedom of expression online to coexist with national security protections? Anyone can go.
Yes, I can start. I think we all know that there is, of course, national security exceptions in many provisions. However, states have just been using this as a convenient loophole and just been using, and shutdowns is one example, using national security as a broad and vague exception to anything they do, without clear demonstration of the connection between the actions and the supposed achieved goal. And they don't, in fact, even articulate what exactly they mean by national security. We have seen in the case of shutdown of Twitter, for example, the government of Nigeria has listed many reasons for, and if you follow the hearings recently, they name all kinds of things, fake news and national security and Twitter not complying to local registration laws. So in fact, when the states, they use this term, but when they actually ask to clarify what do they mean by national security and how exactly shutting down And the internet or blocking a bunch of websites will help them achieve this goal. They, in fact, do not have a clear explanation, and this is a problem. And I'm sure the Special Rapporteur, Freedom of Assembly, and there's other rapporteurs as well who have mentioned this, that it's not acceptable to just say national security to justify any action that the states make. They have to clarify and connect that this justification with the goal and the means that they're using to put limits on our fundamental rights.
Yeah, exactly. And you know, just taking it from there, you know, I know there are a lot of, you know, soft law instruments that describe the three-part test and describe the ambit, the powers of states around these issues. I would like to come to Clement. What do you have to say broadly about the guidance, abundance guidance that states have in restricting, you know, these rights?
Well, let me first say that, I mean, I think you mentioned it clearly, Natalia. There is no really contradiction or there is not contradiction between the need for a state to ensure the national security and to protect also human rights. Because usually we intend, or states intend to say that either we have to protect national security or we have to protect human rights. There is no contradiction on that. Human rights is about security. Human rights is about ensuring that the people are able to exercise their rights. They are able, and I always say to states, you know, you cannot, I mean, when you put security before human rights, you ignore that the best security for any country is where people are able also to exercise their rights peacefully, and they are able to exercise their rights in society that they know that they respect, so this society respect their fundamental freedom. I think everything is in like the test that you just put, the three-part test, meaning that proportionality, legality, and necessity. And if we take the example of internet shutdown, how internet shutdown can comply to the test of proportionality. When you shut down the internet, because, for example, you want to prevent people to protest because you assume that this protest will be violent, then you shut the internet down for the whole country. Where is the proportionality? Right. How do you ensure that the other can exercise their fundamental freedoms, you know? So I think that this is the main question for me. And the state, yes, will resort to this heavy rule or heavy legislation that they have to restrict this in the name of public safety, because in the covenant it's clear. I mean, we have also, I mean, the interpretation of the covenant, because it's put there, you can restrict these rights in this particular situation. Some states do it broadly. They don't even think about that. The covenant also adds that you need to ensure that the restriction of these rights is needed and it serves the democratic society.
Yeah.
Meaning that it should be served the right itself, not undermining the exercise of the rights. So I think the national security is becoming today the best or the fashion way. Every time where you want to stop the exercise of the right, to just say, in the name of national security, public order. But right. I think there's so many literacy today to show that you cannot just resort to that, but you have to go through this particular three-part test and ensure also that whenever you restrict this fundamental freedom, you are restricting it with time banding, with the aim of allowing the right to be exercised in a way that you can respect or you can protect the rights of others, but not just because you want to close or to shut down completely the exercise of these rights.
Right, thank you so much, Clement. I'll come to you now, Osai. You know, just on this same topic of restriction of these rights on national security grounds. In Nigeria, for example, you know, that was the basis for the Twitter ban, but we've also seen component units like states in the country restrict access to the internet in different parts of the country on national security grounds. And, you know, in this case, you know, we have like potentially, you know, 37 authorities that can declare some form of internet shutdowns all over the country. How is that playing out in Nigeria, and how does that tie into the protection of the right?
Thank you very much. In fact, one of the states in Nigeria, Zamfara, telecommunications has been turned off for several weeks now in the name of fighting terrorism and banditry. But we haven't gotten any update yet whether they've been successful in managing and finding out these people that are responsible for kidnapping, abductions, and creating all sorts of violent crimes across that state. That said, it's like Natalia had shared earlier, and also Clement, it seems to be the go-to blanket answer for states in exercising their power without them realizing that there are rules. And not only that, even if for the sake of argument, we say there is a legitimate reason why they've shut down these services, it has to be temporary. It cannot be for a long time. And they have to come back and feedback in terms of what it is they've achieved as a result of taking this measure. Sadly, we are still dealing with insecurity. We're still dealing with the issues that they say that warranted the intervention under the name of security. So it's a blanket statement, but there's no substantive evidence that this actually helps. In fact, right, it exacerbates and exposes the most vulnerable to further exposure to these attacks.
Right. Thank you so much, Osai. And I'll come to you now, Dio. There's a question here from Bonaventure. It was a question, it came in French, but we've translated it. And it's really still around the interest of states and how that plays out in regional mechanisms such as the ECOWAS Court. Since states both fund and appoint the judges of these mechanisms, and this goes beyond the ECOWAS Court, what indeed is the political will, for want of a better expression, that these courts would have in, rendering judgments that really detract from the interests of the states or those who run the states, and, in terms of how much have they used the power they have to correct states' violations of these rights?
Thank you so much, Ikechukwu. I think that's an excellent question. We should know that even though judges of the courts, such as the ECOWAS Court, the African Court, and these other human rights mechanisms are appointed by the states, they are not appointed as agents of the states. They are appointed on the basis of their own expertise and qualifications in the area of human rights law specifically. And so when they get appointed as judges of these courts, they're meant to, issue decisions based on their own expertise and on the basis of their own legal opinions. But then we have seen courts issue decisions, courts and tribunals across Africa issue decisions that have been against the interest of the state or against the interests of those having control of the state in many cases. I mean, just in this webinar, we've mentioned, the case of Amnesty International against Togo. We've mentioned the Federation of African Journalists against the Gambia. And there are several other cases like that from the ECOWAS Court specifically that have hurt the interests of state leaders. That has also seen us, we've witnessed attacks against some of these institutions. About 3 years ago, we saw the decision of the African Authority of Heads of States trying to, come down on the power of the African Commission on Human and People's Rights. Even the ECOWAS Court itself has seen a reduction in its budget, a reduction in the number of judges, which presents, problems for the courts. But then the courts have proven that they can be effective, that they can issue judgments without fear or favor. And I think the only way we can encourage the courts to keep doing that is to keep bringing these cases before the courts and encourage the court to exercise that power. Thank you.
Fantastic. Thank you so much, Dio. we have a few more questions, but our time is running out. And but we would really like to thank you all for your insightful contributions, for the experience you've shared, for the work that you're doing. And we would send some of these questions to you, and we would share your answers to the participants through the post-webinar platform, interactive platform. So just to say thank you on behalf of the organizers, and we would be in touch.
Great. Thank you.
Thank you for having us.
Thank you so much. Bye.
It's a pleasure.
Sure. We will now transition to Lauren, can you switch the screen, please? We'll transition to a session focused on the post-webinar interaction that is key to the conversations we're having, especially because of the fantastic questions that we've received. We want you all to know that this conversation doesn't end here. We know 90 minutes is not sufficient to have a robust interaction back and forth with the speakers and all the experts. So we've set up this platform, and we'll just in a few minutes show you all how the platform works and what you should expect. We'll switch now to Ojigho from NULAI, who would be leading us in this session. Hello, Ojigho.
Thank you. Thank you very much, Ikechukwu. Hi. Hello, everyone. So the platform, the post-webinar interactive platform, would be the NULAI Center for Clinical Legal Education. I'm just going to share my screen. I've been told I have 5 minutes, so I'm going to try to keep it within 5 minutes. So yes, this is it. I'm going to re-log in for the purpose of this session. I would leave this link in the chat box. So the link is ccle.nulai.org. And once you get in there, you log in with your details. In the email was sent out earlier, we did mention that you will get a guide. So no worries, this is brief, but you will have a more detailed guide on how to navigate the platform when you receive that email, as well as your login details. So I'm just going to go ahead and log in. So of course, as with any other platform, if you would want it to store your username for future purposes, you can just check that box. Oh, do bear with me. I've been having a bit of network challenges.
Can we switch it up to my screen? I'm
going to turn off my video to try and... Oh, okay, great.
Yeah.
That'll be fine. Okay.
Lauren, please, if you can switch, yeah, I will just share now. So we'll be using the guide instead so that we can, since this is what everyone will be receiving.
No, we're going to the platform directly.
Okay.
Oh, okay.
Yeah.
So just scroll down to login. If it's okay with you, I prefer to do a practical one. So if you could just log in onto the platform. I've just shared my password with you.
Okay, we have this.
Yours. That's fine.
Yeah.
Oh, yes. And so you just click on protecting civic space and digital rights through strategic litigation. That one, yes. That's on there on the home page. Click on that again. Protecting, yes. So here we are. The background there is hyperlinks in case you want more detailed information to the webinar and all. If you could please scroll down.
Okay.
Right into webinar 1. Oh yes, sorry, before webinar 1, we do have the meet and greet there. So, I mean, given that the 90 minutes is not enough to have all that networking, we want to imitate the realities of a physical event. So we could just meet ourselves on there, introduce ourselves and network as well. So it's really as easy as just clicking on it, typing in your details, and then you just send. That's it. So you just click here to enter the chat now, and that's it. So webinar 1, we're going to be using the discussion room 1. Yes, and there's already a question there, national versus regional courts, which do you prefer and why? We're also going to be having more questions. And of course, while discussing, for instance, there's national versus regional courts, if you do have any question relating to this, or you want to start a new topic, you just simply use the add a new topic button right there to your left, just under the question. Could you move your cursor? Yes, so that you can see what I'm talking about. Yes, great. Thank you. So you put in your subject and your message and you just post to the forum. Can we go back, please? No, to the question. Thank you very much. Oh yes, I just wanted to show you that instead of adding a new topic, if you would just rather prefer to continue or respond to someone, like you can see there, Ikechukwu left a comment already. You could just click on, yes, he has his cursor there, discuss this topic, and you'll be able to join that conversation. Can we see? Thank you very much. So yes, we already have that. We did that while we're testing it out. So, and if you would like to even respond to a responder, someone who has responded to the starter, you could also reply as well. But like I said, it's a pretty much simple platform to navigate. But we would be sharing the guide and of course leave you with contact details to request for help if at any point you need assistance with accessing anything on the platform. Thank you very much, Ikechukwu, for your help there.
Yeah, thank you so much. Thank you so much, Ugochi, and thanks, NULAI, for hosting that platform. We've now come to the end of today's webinar, and we would like to thank all our participants, and we'd like to also thank all our panelists for just the great work, the great conversation. The conversation just started. We would be sending login details for you to join the interactive platform, and we would be answering all other questions and taking new questions, including the question we have there already. We'd really like to thank our interpreters for the phenomenal job that you have done, and we can't thank everyone enough. we would like to mention that this is the first part of the 3-part series. The next part of the series, the second part, Eastern Daylight Time in DC and 3 p.m. West African Time or GMT +1. And the links have been sent already. We'll be discussing the strategies and tips for crafting comprehensive litigation strategies to respond to civic space and digital rights attacks and the challenges that we've discussed today. And the third session, which we see many people are really interested in, implementation and the use of decisions from regional mechanisms for advocacy, would hold on October 19, that's in 2 weeks, at the same time. And we would have the special rapporteur from the Inter-American system join us next week, as well as we'll be discussing in detail this case that everyone talked about today, the Amnesty International Togo against the Republic of Togo. It's like the first strong decision from a regional mechanism, from an international mechanism that speaks to the fact that the right to access the internet is an essential right because of how it impacts every aspect of our life. With that, would like to thank you all. Feel free to share thoughts about the webinar on social media. The hashtag for this webinar series is Civic Space Series, hashtag Civic Space Series. We'd love to interact with you and we'd love to hear more from you between now and the next webinar. Thank you so much and see you next week.